I think we can officially begin now. Thank you, Sonu. Thank you. Hi everybody. I am Sanya. I am a learning manager at Lawctopus Law School. I'm also a practicing advocate, and today we are going to discuss how to read judgments from a practitioner's as well as an academician's point of view. We also have Varshika Sharma with us, who is the faculty of legal research and writing. She is a gold medalist through and through. Over to you, Varshika, to tell them a little about yourself.
Yes, hi everyone. So as Sanya already introduced me, I am a learning manager and faculty at Lawctopus, and I teach legal research and writing course. Other than that, I am really passionate about education, and one of my interests also include like traveling. That apart, I think Sanya, we can formally start the session.
Yes. Thank you everybody for joining us. We hope that you have a good time and you learned something new towards the end of today's session. Before we start with the topic for the day and our agenda, there are some things that we want you to understand for us to have a smooth session because we have limited time together. For all the chit chat, the things that you want to discuss with each other and also maybe with us, please put them in the chat box right in front of you where you're writing right now. Also to introduce yourselves and tell us a little bit about yourselves. Please choose the option all panelists and attendees in the chat box when you are interacting with each other or with us. In case you have a specific question about something that we're going to discuss in the session, something that we're going to talk about, anything specific that you would like us to address, please put them in the Q&A box. In the Q&A box, the questions get collected. When I am talking to you, then Varshika will be looking at the Q&A box and trying to answer all of your queries. And when Varshika is talking to you, interacting with you and talking about a particular segment of today's session, then I will be looking at the Q&A box. All the other questions that we think are important for everybody, we'll be taking them live towards the end of today's session. The last half an hour is for your questions only, but no questions in between. And some of you are raising your hands. Please lower them because then we'll, have an idea that maybe you want to come on audio and talk to us. But that will disrupt the flow of the class. So please lower your hand, everybody. And we have some polls and we have an end of session quiz, and there are some things that we want you to keep in mind where we are trying to set your expectations. So that will be covered by Varshika. So Varshika, if you could tell them what they can expect.
Right. So, guys, just to set the expectations right and clear at the onset only, nothing that we say in this entire session is to be considered as legal opinion. We understand that a lot of you have joined us and we are discussing a very recent judgment, so chances are that confusion might naturally arise. So, please don't take anything that we say as legal opinion at any point of time. Second thing is, the manner in which we have approached case comment and case brief for today's class is merely indicative. Nothing at any point is the only manner in which you can approach a case comment brief. Make sure that you are keeping an open mind and understanding that this is just one way. It is a way that has suited us, that helps us to understand and approach a judgment reading and analyzing a judgment in a better manner. So understand that this is merely indicative, but of course we will be talking about what other approaches you can follow. Now, yes, a very important part is certificates, and we will be talking about certificates towards the end of the session in detail. But a circulation form will be circulated towards the end of the session, and that's where we'll be telling you how you guys can receive a certificate. Once you fill out a form that we will be circulating towards the end, you will receive a certificate within a week only. So please understand that we will not be issuing certificates today itself. Today, you have to stay till the end of this session in order for you to be eligible to get this certificate. Now, of course, guys, just one thing which is slightly difficult, which might be a little difficult for you to grasp, is that we have limited time. So we might not be able to take all the questions that come up. We will try to take as many as we can. We'll try to answer as many questions as we can in the Q&A box and take as many as we think are relevant enough to be taken live towards the end of the session. So just wait till then to get your questions answered. But again, please understand that it might not be possible for us to take all the questions. Now, just to quickly move on to today's agenda. So, yes, Sanya.
Right. So today, basically, we have gathered here to understand how to read judgments. And ever since law school, ever since the first day we joined law school, we've been asked to read as many judgments as possible. God knows I never listened. I never read all of them thoroughly. I couldn't fathom just exactly how you're supposed to go through hundreds and hundreds of pages of something that you don't understand and you don't see the point of. And in law school, the only purpose for me to read the judgments was to understand how much I need to know to pass my exams. Of course, that's not true for Varshika, as she will discuss with you, since gold medalist and all. So today, all the things that I realized after I started practicing and how I should have gone about understanding judgments and what it takes for you to present a judgment in the most coherent way possible at the time of hearing, and also the importance of analyzing the judgment and having your own opinion, critically thinking, is all going to be discussed. By the end of today's session, you're going to understand how to read a judgment, how to paraphrase, how to reference. Paraphrasing and referencing will be explained to you by showing you the case brief and the case note that we have prepared. You will also understand the difference between the case comment and the case brief. Now, these terms, case notes, case briefs, case comments, they are often used interchangeably. There is no hard and fast rule that one term has to mean one particular thing only. But for the purposes of today's session, we want you to keep this in mind, that when we are talking about case comment, we are talking about case analysis, the opinion that you frame on a particular case law while you are doing some academic writing, writing a paper for a publication, or trying to just go deep into the analyzing part of the judgment to understand it better. It's also good for your CV, everything else that will be explained to you in detail by Varshika when we look at the order that we shared with you from an academician's point of view. And when we talk about case brief, we are talking about deconstructing the order, deconstructing the judgment in a manner that helps you not only know what are the important points of your judgment, but also where exactly they can be found, which paragraph number, which page number, what points do you need to keep in mind while you're trying to make an argument, support your contention. So that is the meaning of case brief for today's session. So please keep that in mind. Please use the Q&A box. And just as Vashika explained to you, towards the end of the session, we will be circulating an expression of interest, a Google form. Only if you fill out the Google form will you be eligible to get the certificate. And that is how we will know that you stay till the end. So please wait till then and be patient. Give us a patient hearing and try to understand just exactly why it is important to read a judgment in its totality, in its entirety. Why, contrary to what our heart says and what we think we should do, skimming through is not the answer. It is not the key. Trust me, I now understand it, now that I don't have the professor sitting over my head making sure that I truly have gone through all the pages. I understand why it's important now, and we're going to talk about that throughout today's session. So over to you, Varshika, if anything you'd like to add to that.
Yes, so before we officially start the discussion on comment and brief, I want to point out a couple of things about judgment reading. As Sanya has already mentioned, that skimming through a judgment is not an option. Whether you are writing for an academic piece, whether you are going to present your arguments from the case in front of a judge in a court of law, it does not matter. Try to read the judgment, and we understand that sometimes it is not possible. We don't have to go through each and every judgment, which is why commentaries come in handy, case summaries, head notes of case, etc. come in handy. But when you are just starting off, when you are starting off your legal journeys and careers, especially when you are in law school, please make sure that whatever time you get, whatever time you can invest in this particular aspect of law school, which is judgment reading, judgment analyzing, understanding, etc., make sure that you are reading it thoroughly. So, as I said, that when we start law school, it seems like a tedious task to read an entire judgment. Like when I was in law school, the first assignment that I received was to analyze a judgment. That's how important it is considered in law school. And even when you are not even asked to just analyze a judgment, you're simply told to say read a landmark judgment to just understand how judgments really work. Now, what is the importance of reading this judgment? Like, I just want to quickly point out a couple of things which you may or may not already know. So, first of all, the foremost thing is what the judgment says, like what the ruling or the wording of the judgment is, to familiarize ourselves with the law that has been dictated in a particular judgment. Second is to understand how judgment writing really works, how a judge's mind is working when a judgment is being written, why is he favoring a particular side over other. Third is it helps you understand how to make arguments, and that is something that Sanya has already talked about in a bit, and she will be delving a bit deeper into it when she explains case briefing, etc. So, but I want to focus on another two very subtle things which develop when you read judgment with utmost concentration and when you read judgment with sincerity that it requires. So that is one aspect is the art of developing critical thinking skills. When you read a judgment, of course, it summarizes the facts in most of the cases. It will also talk about arguments the parties have given. So when you read arguments of both sides, right, it automatically instills in you this sense of questioning one side as to why one side is saying this and how he's framing the arguments for that side. On the other hand, you are at the same time being told that why the arguments of that first party do not hold ground, and it is being explained to you by the other side that these are my arguments and this is how the court should produce. And then after that comes the court's ruling, the judgment, the reasoning part of the judgment, where the court explains as to why it is favoring one party over another. So that automatically instills in you this sense of questioning, asking each side, asking the court, asking the judges as to why they are saying what they're saying. So that is a subtle thing which develops in you: critical thinking, critical reasoning, critically analyzing and understanding any legal writing that comes in front of you. And after that, of course, it helps you in developing your academic writing skills. Like it just case and reading a judgment doesn't just stop with reading it. As I told you that you cull out the law from the judgment, you cull out the arguments of the parties, but at the same time, you're also developing that critical thinking skill, which is going to help you in even furthering your academic writing style. Your research and writing skills automatically start developing when you read the judgment in its entirety. I genuinely don't remember any teacher of mine telling me, even in law school, when I just started off, to just read the summaries or let's say just skim through a judgment, despite them understanding the fact that there are so many judgments. Even if we talk about just landmark judgment, it's just too many to even count. So then how are we supposed to read all of them when they run through pages and pages, hundreds of pages? So despite understanding that, I was never told to just simply skim through a judgment. I was always told to read the judgment, because only then the entire sense of judgment starts building in you, that what it actually tries to say. So please remember, especially if you are just starting off your legal journeys, that you should not skim the judgments, as many as you can, especially the recent judgments that are coming out. They're so beautifully written. I remember, I understand that, older judgments were so complicated to go through, so difficult to understand, because the parts of the judgment were scattered, judges concurring opinions, dissenting opinion. It was very difficult to cull out each separate part. But nowadays, the judgments themselves clarify what the issues are going to be, that is going to be discussed. So you don't even have to put in that effort to figure out what the issues are that are being discussed. So make sure that you are reading those judgment in entirety, because first of all, of course, you have time. Second, you need to develop critical thinking skills as a lawyer. And third, one very important thing is that you don't want to miss out on those small details, be it a part of obiter dicta or be it a part of dissent, because you never know when an obiter dicta will become the law of the land, when a dissent will become a majority opinion and hence law of the land. So make sure that you are going through each and every part of the judgment. I'm sure all of you, if not all of you, most of you will be aware of H.R. Khanna's dissent in ADM Jabalpur, which became the law of the land eventually a couple of years later. Similarly, so many instances of dissents becoming majority decisions. And if while knowing, while understanding or reading about the judgment, not the judgment, you don't think about the dissent. In hindsight, of course, you might think about the dissent, but at that instance, if you don't, then chances are that you will miss out on these important points which were actually part of the judgments which you missed out on. Again, so it cannot be emphasized enough that how important reading a judgment and reading it thoroughly with utmost sincerity and understanding is important from an academician's point of view, because general development of critical thinking skills and eventually you being able to utilize those critical thinking skills in your academic writings, in your answer writing, and anything that you are a part of as a lawyer, it just does not, it's not something that can be compromised with. So Sanya will be taking up the lawyer's bit of it in a bit detail, and then we will delve into the sections about case brief and comments separately. Sanya, please go ahead.
Thank you so much for that, Varshika. Building on that, when I look back now on my law school journey and think of what was planned for me, things I did not really understand then, reading all of those judgments and making, elaborate notes on them, trying to understand what the law is, what the judge is, holding in a particular judgment. The idea to go behind the rationale, to know the reasoning, to know the arguments that were happening in a courtroom, to actually understand what went through a judge's mind while pronouncing a particular judgment, which then became the norm, the precedent, is something that I appreciate a lot more now that I started practicing. We all know that we are a common law system, we are a common law country. We rely heavily on our precedents to make arguments at the time of hearing. So when we are making arguments, we're referring to all of these judgments, all of these precedents. And the way to do that, how exactly can we make it as convenient for the judge as possible, is something that we rarely think about, especially when we are still in law school. When we are making an argument and we are saying that this particular judge held this thing in this judgment because this was the reasoning that was given and this was held in this judgment, the facts are the same as my case, and since this has been held in this judgment, the same order should also be passed in my case by this particular court of law. When I'm trying to make an argument in the simplest terms without going into the legal jargon and the formalities, the judge will not believe me just because I'm saying something. The judge will not take it on the face value just because I am saying that the facts are similar, just because I am saying that this point supports my contention, my argument. The judge will not say, okay, yes, granted, you can feel whatever, you can say whatever, I agree with you. There's this thing called art of persuasion, art of advocacy. There are arguments at every stage when we approach the court with a case. And when those arguments happen and when we try to cite judgments to support our arguments, it is not always that the judge will be familiar with every single page of the judgment. They will know just exactly what was held and why it was held, especially if it's a recent order. It can get hard for even the judges and other lawyers to keep track of all the judgments and to know just exactly what is being said on every page number. But you citing that judgment, it becomes your responsibility to know exactly which point you are making to support your argument, where exactly that point can be found in your judgment. Especially if the judgment runs into hundreds and hundreds of pages, then if you are making that point and you're saying that this was held and this was upheld and this was reversed, or this goes in my favor, then when the judge asks me where has this been written in the judgment, I have to be prepared with that. I have to be prepared with the exact paragraph number and the page number where it has been held. I have to ask the judge his or her permission to approach and give them the judgment's copy, and for them to open the particular page and read it from that page. And it's not like that the judge will allow whatever you're saying without going through the entire judgment. They will take time, they will go through it, they will analyze it themselves. But if you are prepared with the exact page number and the para number, you will come across as somebody who really cares about their case, who really care about the time of the court. We know with the overflowing dockets, everything going crazy, especially in today's day and age, the court's time is more precious now than ever, and we have to respect that as the officers of the law, as the assistants of the judge in delivering justice. We have to make sure that we are not wasting the court's time. And that is when a case brief comes handy, because you're not only deconstructing the judgment by paraphrasing something, not paraphrasing something, something that we will look into just in a short while. I'll show you my brief on the order that we're going to discuss today. We're going to go through it piece by piece to understand how exactly it was created and how it helps. But to give you
Adya,
an
just a second. There is a request to go a bit slower. So,
all
yes,
right,
Tanish, we can do that.
sure, I'll do that. Thanks, Varshika. So what I was saying was that when we are presenting our case, when we are making an argument before the court of law, before the judge, we have to be prepared with just exactly what points from a judgment we are citing and where those points can be found, just exactly which paragraph number and which page number that point can be found. And it becomes even more difficult to understand that when the judgment goes into hundreds and hundreds of pages, unless you have a photographic memory, in which case I am truly envious. You cannot at the drop of your hat just say that, okay, this point is on this particular page at this particular paragraph number. Yet the judge, the opposite party, will expect you to know that at the time of hearing. So to do that, a brief really comes in handy. It helps you remember the important points. It helps you organize your thoughts. It helps you understand what you're reading, what exactly is the purpose of you citing a particular judgment. And all of that builds from your experience of judgments from the law school. Because in law school, the judgments are your very first introduction to what goes on in a courtroom. We have different hearings, we have different stages of proceedings. Every stage, every hearing is set for a purpose. There is an agenda for that hearing, and when that agenda is to be fulfilled according to the procedure, then you have to take certain things into consideration while being present for that particular hearing. So the purpose of the hearing correlates with what exactly you will say, what you won't say, how you will back your arguments. Is it even time for you to argue? So all of those things are understood once you start practicing. But in law schools, when you read the judgment, when you know, okay, so the entire sequence of events is right in front of you. The facts of the case are explained to you. What were the arguments that were raised by different parties? What was held in that particular case? And what was most importantly, what was the reasoning that was provided by the judge while making their decision in favor of one party and against another? All of that can be found in your judgment if you read it like you really want to understand it. There is no shortcut. There is no way you can just skim through something. Even in code of law, where everything is questioned constantly, in evidence, if you just provide a particular screenshot of a WhatsApp chat and in evidence with an affidavit of section 65B of Indian Evidence Act, If you just provide a particular screenshot, the judge will not admit it into evidence because the context of the conversation is not clear with just one particular screenshot out of context. You risk completely negating the entire meaning of what you are saying if you do not put things into perspective, into context, with a holistic understanding. And that cannot happen until and unless you read the judgment in its entirety. So that's your very first introduction. These days, we also have live streaming of court proceedings happening by the Honorable High Court of Gujarat and Karnataka. You can find those on the YouTube channel. You can see how judges interact with lawyers, how limited time they have, how lawyers interact with each other, and how they make their case. You can see all of that now. But the judgment is our very first introduction into a courtroom, if you see it like that. And also, what do we exactly mean when we say in a courtroom that this may be taken on record or this may be placed on record? All the important hearings, all the important points that are raised in a courtroom are recorded in the order, in the judgment. The judgment is the culmination of the entire journey of the case, the entire life cycle of the case, ever since it was first presented. So you have to be absolutely sure just exactly what you're getting into. What is the purpose for you to read that judgment? It's not just to pass your exams or just to ratify the citations and make sure that, okay, yeah, I know this judgment also, I know that judgment also, but you don't really know what's going on. What was the impact of that judgment? What was the interpretation of that judgment? And how to use that judgment in your own arguments? You won't know unless you read the judgment completely, thoroughly, page by page. For today's session, we are going to focus on the recent order that was passed by Justice Venkatesh of Honorable High Court of Madras. The reason we picked that particular order was also because this is the Pride Month. And we really wanted everybody to get a chance to really know what Pride Month stands for. What is the LGBTQI plus community? This is, I think, the first time that a judge himself underwent educative sessions to evolve, to understand something that he knew he was prejudiced against, that he discriminated against unconsciously or consciously. But he could not pass an order in a case that pertained to a lesbian couple without really removing his biases and prejudices and trying to understand what this community is all about. And that, in my opinion, stands testimony to our ability to be inclusive, to be kind, to really make a change, and how easy it is to do that, to just accept, to just even try to understand somebody that's different from you, somebody that you just think is not normal, maybe because that has not been your normal. But there are different ways to look at things, and there are different prejudices and biases that we may hold. And this judgment, this order of 7th June 2021 by Justice Venkatesh, I admit that it must have been a very easy read, because the entire order was written from the heart that the judge endeavored since the very first day. So for those of you who have not read the order, I urge you to read it after today's session. Although we have prepared case briefs and case notes on that order, but you will be able to understand from the brief, from the comment, what the order is all about. So that is how we've prepared it, and that is how you should approach it, as we will be discussing in detail. But just to give you a brief background of the order that we're going to deconstruct today. So it's about a lesbian couple who are the petitioners. They fled Madurai, that was their hometown, and they went to Chennai. They are 22-year-old and 20-year-old girls. Their parents then filed a missing girls complaint against them at their nearest police station, and FIRs were registered. It is not uncommon, and it is not a hidden secret, a hidden fact that people from LGBTQIA plus community have faced harassment and discrimination on all fronts for the longest time, and especially on the end of the police as well. So to avoid harassment and threats from the police, from their parents, and to be able to live their life as grown adults on their own terms, they filed a writ petition under Article 226 before Justice Venkatesh in Madras High Court. And this then became a specially ordered case where, even after the judge had asked the police, directed the police, who were the respondents, to close the FIRs, to close the complaints against the girls, the judge also ordered for the girls' counseling, their parents' counseling, in an effort to bridge the gap between the parents and the children, and also for himself to understand from a professional's point of view how situations like these can be resolved, what goes on in the minds of people from the community and their family. Now, if you would have just skimmed through the judgment, you could have thought that, okay, so the judge is ordering counseling session for the petitioners. Petitioners are a lesbian couple, so maybe the judge is trying to insinuate that the petitioners, the lesbian couple, the people from the community, need to be psychologically analyzed. Only if you went through the entire judgment, you must have understood that the psychoeducation counseling sessions were not for the people from the community or the petitioners. They were for himself and also for the parents to step into the shoes of somebody who goes through something like that, to try to understand them, to try to unlearn everything the society has told or try to force upon the judge before they pronounce an order and issue guidelines to different ministries, to the government, to the state, to the police, to ensure safety and protection for members of LGBTQIA plus community. Because we've had different judgments, and those judgments have also been cited in the order. We've had the enactment of Transgender People Protection of Rights Act in 2019, and despite all of that, there is still harassment, there is still lack of awareness, there is still lack of understanding of what this community goes through. And that is why the judge said, I am the society, and I have to bring about this change within myself before I preach, before I start telling other stakeholders just exactly how they should be conducting themselves. And he also wanted to represent the institution, that is the judiciary, for somebody to be belonging to that particular institution and to be doing something like that. It's inspiring, it's hugely supportive to the community, and it ushers in a new era of hope. And that is why we really wanted you to read this order. And today, as we go forward, we will be deconstructing this particular order, where Varshika will share with you how she read the order, and I will share how I read the order, and she will talk about how she prepared the case comment and how you should go about it, and I will talk about how to prepare a case brief. And this is only indicative. Please remember, this is what works best for us. This is not an authority on how you should go about it. We're just giving you ideas, making you think about it, and then devise your own ways that work best for you. So over to you, Varshika.
Thanks, Anya. So, all right, guys. So, without wasting any further time, let me just quickly delve into the case comment part. Now, before I talk about the case comment, I just quickly want to show you my judgment, my copy of judgment, and hopefully it will help you see what we're talking about when we say read the judgment very carefully. So, just a second, I'll share my screen quickly. Okay, I hope my screen is visible. Now, if you go through this entire copy of my judgment, you will see there are multiple places where I have highlighted, put comments, put extra tick marks, put it multiple colors, highlights. Now, one thing that entirely stood out to me in this judgment, of course, other than the things which we generally look out for, like what the judgment was about, what were the directions given, what were the facts, what were the arguments, what was the major law, contentious law, all of that was definitely there. But the one thing which completely stood out to me, actually, they are twofold. One is the actions of the judge, and the other part is this one sentence, that is, I am the society. Now, this is something which entirely blew my mind, because a judge saying something like this in a judgment is something which has not been witnessed many times, right? So this is what I wanted to talk about. This is what I wanted to focus on, because as a constitutional scholar, constitutional law scholar, I have read a lot about transformative constitution, right? And this part where the judge said that I am the society. Now, this completely blew my mind, because for a constitutional law scholar, when transformative constitutionalism is talked about, it's generally talked about changes in the law, amendments, enactments, interpretations, all of those things, all the core legal aspects of things. But here, when in a judgment it is reported that a judge is doing something to after going out of the way and then saying that I am the society, it is me from where the change begins, and he sets an example in front of the society about this particular fact that I am the society. I am going to learn, first of all, unlearn whatever biases I have learned throughout my growing up, and then relearn as to what needs to be learned with this transforming society. So this is something that I wanted to show you. This is one part which is something that struck me, and this is exactly the point on which I went about writing a case comment, which I will share with you guys. After that, I also want to show you a couple of things. First of all, just look at this copy. It is completely underlined. I have underlined every single aspect which made sense to me, everything, so that when I go back to the judgment, I don't have to look in a disarray for things, what thing is where, whatever is happening where. So I use different colors of highlighting, underlining extra important points. I made sure that I had my own manner in which I'm highlighting that. But what I do want to show you is something where I put my comments also, so that I don't forget anything that I want to talk about and it shouldn't be missed out on. So I'll just quickly show you, and then we will move on to the case comment part. Now look here. One second, guys. It's so much. Okay, yeah, here it is. So now when the court proceeds to issue following interim guidelines or directions, right, I had put this comment that this is mandatory. Now I remembered, which is why it is important for you to keep all the concepts which you learn throughout law schools in the back of your mind, so that they quickly come in handy whenever you're doing any kind of academic work or any kind of lawyerly exercise for that matter. So I remember this from interpretation of statutes, that there exist a mandatory guidelines that might be provided in a judgment, and also recommendatory guidelines, right? So in this judgment, the directions were actually divided into two. One was mandatory part of the guidelines, and the other one was also the simply recommendatory part of the guidelines. Now, these were the mandatory parts, which were in the form of continuing mandamus. Why I'm telling you all these things is because you guys need to understand how to not just read the judgment in isolation, but also be in a position to be able to connect it with different subjects, with different topics, with whatever is going on currently in the society. So this is where I just put a simple sticky note for myself, that I need to remember that this is what I can talk about when I'm doing my case analysis, right? So because these were mandatory guidelines, right? These were the guidelines which had to be absolutely fulfilled by the concerned authorities. But on the other hand, these were also recommendatory guidelines. Sensitization programs was essentially the crux of what recommendatory guidelines were all about. Now, in this, I had something in my mind that maybe I'll criticize the judgment based on the fact that how the judge went about giving directions for this particular case, but then what happens for the upcoming judgments. But then I also remembered the doctrine of precedence, that this is a high court judgment and it needs to act as a precedent. It is going to act like a precedent. So then the following judgments are obviously going to follow it, whichever falls within the jurisdiction. So just see, everywhere I have put my comments wherever it was needed. I was telling you about these recommendatory guidelines. So again, recommendatory guidelines, what importance do they play? Are they important enough? If they're not being followed, nobody is going to follow up on them. So then what's the point of even recommending anything when there are no sanctions going to happen after that? So this is the way in which I read the judgment, as I showed you that I had multiple things. But then, of course, towards the end, something that completely stood out to me, something that I really wanted to talk about, was the fact that the judge himself acted like a transformative constitutional in actual practice. So that's what I wanted to talk about. And I left all these things for later on. Right now, as I started off with doing my case comment, this is something that stood out to me and I wanted to talk about it. Now, let's see how I actually did the entire case analysis. And again, I'm going to share my screen with you guys. Okay, but before I begin, one question to all of you is, look at this. If my screen is visible, guys, look at this. Please feel free to answer in the chat box. And Sanya, please take a note of what kind of response we are getting so that we know what it is. So the question to you guys is, do you think these points which I've mentioned here, from relevant facts to background, procedural history, etc. do you think all these parts, if I discuss about this judgment, is a case analysis? Okay, tell me guys, this is a question to you. Please post your answer in the chat box.
Yes, please write yes or no in the chat box, whatever you think.
Just write a yes or no. Do you think, if this is all I talk about the judgment, if I state the facts, background, history, issues, arguments, ruling, reasoning, ratio, everything, all the things that are mentioned here, if I talk about all of them, do you think that is a case analysis or a case comment? And guys, please don't confuse the term case comment and case analysis. For now, we are using it as the same thing. It is just the same thing, case comment and case analysis. Don't go by the terminology. Please go by what is required to be done. And also, case brief is entirely different, which Sanya will explain. Here, case comment is case analysis only. It's different from case summary or case note. So Sanya, what is the response that we received?
So Varshita, majority of them are saying yes with a sprinkle of no. Just one or two no's.
No. Okay, okay. Okay, so guys, this is what we want to actually deconstruct, and this is what we want you to unlearn and learn from Justice Venkatesh to unlearn things. Now, case analysis or case comment is not simply explaining all these points. It becomes an important part of a case analysis because until and unless you have deconstructed the judgment to cull out each and every aspect, including the facts, the arguments, the issues raised, the judgment, the reasoning, the ratio descendendi, everything that is discussed in the judgment, you need to know and understand very well before even thinking about doing an analysis. So that's the difference. This is just a preliminary part of doing case analysis. When I told you that when I read this judgment, my first reading was only about just reading the judgment for the sake of reading. I did not have any intention of doing a case comment or analysis on it because you can't know whether a case is worthy of even being analyzed before reading the judgment and before culling out all these things. Now, it is Pride Month. First of all, I know that it is very important to talk about LGBTQIA plus QI plus community in general, because it's a marginalized community and they have faced discrimination over centuries. And we need to talk about what kind of discriminations they face. However, after Navteet Singh Johar's decision, a lot of clarity was brought about. And last year's 2019 legislative enactment of Transgender Protection Act 2019. So that act gave further clarity that the judiciary and legislature was in sync with respect to the rights of LGBTQI plus community. But is the society in sync? So this judgment actually talked about the fact that how can we bring about society in sync with what the law as well as the judiciary has already pronounced or said. Because merely making a legislative change, although it can be a trigger factor and a propelling factor in making slight change in the society, but that's not the only place from where you can bring about change. You can't impose change from above. So top-down approach does not work for changing the society. What works is when you when you do it, or when you talk about, when you bring about that change from in a bottoms-up approach. So that is why I have actually asked this question. Now, what do you think, whether this is a case analysis or a case note? Now tell me, guys, what do you think? If there is nothing new, is there any analysis that you see in this entire portion? Any part which talks about analysis, anything, anything? Is it just not the parts of judgments rearranged in a proper systematic manner? Is it not just that? What analysis are you doing if you're just talking about these points? No analysis, right? Absolutely no analysis. So that's what I want to talk about. And case comment, guys, don't confuse. Case comment is also case analysis. These can be used interchangeably. So this is simply a case note, or a case summary, if you want to call it. If you also include the part where you're also talking about what all previous judgments the court talked about. So case note or case summary, that's what this is. However, it is very important to start off with your analysis. Please understand that. Now, so since this is an important part of case analysis, we need to understand how to figure these things out in a judgment, right? So I had kept small pointers about the fact that, you know, what relevant facts are. So these are the most important facts, which of course, you cannot really tell which are the most important facts until unless you read the entire judgment and see what all facts propel the judges to give the judgment that they did. Now, these are the facts which actually lead up to the claim being made in the first place. So this is how you figure out relevant facts. Now, in the present manner, the facts are very clearly laid out for us. So we don't need to put in much efforts. But in a lot of times, first of all, when we are reading Supreme Court judgments, chances are that the facts might not be entirely laid out in the final Supreme Court judgment. So you need to go back to the original complaint when it was filed for the first time, when it came out in the court, where the facts were ascertained, which is the job of lower courts. When the facts are ascertained, so you go back to that original judgment to figure out the facts which are important to you. Although in the Supreme Court judgment or High Court judgment, the important facts are mostly laid down for you with ease. You don't need to do much about it. Similarly for this judgment also. Background procedural history, in this particular case, there's no procedural history because this judgment came out directly to the High Court. But yes, there were previous orders which were given by the court, and the summary of those previous orders is also laid out to you in this final order itself. So again, you don't need to put in any efforts. But if it is not, then you have to go back to all the previous hearings, orders, judgments, etc., to call out this procedural history. Issues, yes, one of the most important things. Now, in this judgment also and otherwise also, issues are mostly not really laid out for you as it is. You have to figure it out after reading the judgment. And these issues, guys, we at the stage of High Court or Supreme Court, we are mostly concerned about the law and not the facts. So make sure that the issues that are identified are actually on a point of law, right? So that's important. And if you're not able to figure out that how to call out these issues, just think about the fact as to what did the complainant want, or what did the petitioner want. In this particular case, they just wanted that they be left alone, their rights be protected and all of that. So of course, they be left alone is a factual situation, but again, it can be legal when we talk about it in terms of Article 21, which is also one of the issues in the case. Then second thing is, they should not be discriminated against, because if it were a heterosexual couple, then chances are that the police might not have even gone to question them because of the fact that they are adults. So there is no real legal requirement of the police to go and question them. So all these issues of regarding Article 15 and Article 21, that what are the rights of these people were being asked to be reiterated. So that were the issues in this particular case. And you identify it when you read the entire judgment. In the initial part of the judgment, if you go through it, What is being talked about is simply the fact about how the judgment went through the psychoeducational sessions, his summary of that. And the second part talks about his conversation with one of the trans women. And after that, only the entire analysis of legal issues start. So you have to be patient to go reach that level where you are actually talking about the legal issues. Now, of course, arguments of the parties are important. As I said, even in the beginning of this session, that reading the arguments of the parties actually can be a very good factor which helps you in thinking critically about the judgment. So here you don't even have to do much like you have to do in academic writing, paper writing, where you have to figure out who has gone against this particular line of argument and then see what they have said. Here you have it laid out in front of you as it is as to what are the arguments of one side of the party and what are the arguments of the other side of the party. So when the court leans in favor of one, then you have your easy grounds of questioning that leaning as to why are you leaning in this favor when arguments are clearly presented to you by the other side. Also, one good thing is that they have already done a lot of work for you. Like, of course, they want to win the case, right? So they will be presenting the arguments in the best possible manner. So that is another thing that you need to keep in mind, right? So with respect to issues, arguments of the parties, be very clear, be very diligent in reading the judgment. A lot of times you'll ask me that when we read the judgment once, nothing enters my mind. Like when I was asked to do one case analysis in my first semester in college, it was on R.D. Shetty. It was a long judgment and so much had been written about it. I didn't even know how to understand the judgment, let alone how to cull out all these parts of the judgment and then go about doing the analysis. So very difficult, very difficult. So just be patient, read the judgment once you will see that some part of the judgment might seem relevant to you, other parts won't make any sense. When you read it a second time, you will see that okay, now it is making sense a little bit. Third time when you read it, you'll start thinking not just in terms of what is written, but then about how you can relate what is written to whatever you know generally, and sometimes things that you may not know. Because what I have a habit of doing, and you should also inculcate it probably, is that when you read a judgment, whatever terminologies are there that appear in a judgment, like I'll give you an example of constitutional morality, which was talked about in Navtej Singh Johar judgment. That is something that's a very academic and philosophical term, very heavily philosophical term, which was used and explained in the judgment. So to a larger extent, it will be explained in the judgment only, as was done in Navtej Singh Johar. But you probably will need to put in that extra effort to do a little bit of Google search and understand the concept in a more holistic manner as to what the other courts of the world are saying about it, what the scholars on that particular aspect are saying about it. So that little bit of extra research will give you that edge that you need to actually analyze the judgment, because you might find flaws in the judgment when it comes to the understanding of that particular concept. If nothing else, you might have something new to say, as I will talk up to you about in the comments that I've written, which I'll again show you. So these are the things that you need to keep in mind. Now, of course, interpretation of law is the part where the court examines the law in dispute. Like in this particular case, Article 15 and 21 were again examined in detail, despite the point of law being ascertained in Navtej Singh Johar. So it was essentially a reiteration of what was said. The only new aspect to the judgment was what the actions of the judge in reaching the conclusions that he did, and also the fact where he went through that psychoeducational session. Also, the part where he reiterated those sessions in the body of the judgment itself. Very important. Again, his directory and mandatory guidelines are also very important to be discussed, which I personally have not taken into consideration for my case comment. But as I told you, that you can talk about it. Like the timelines of a lot of things are not clarified as to if sensitization has to be done, then how often it needs to be done, who needs to do it, who will do it, and if there is a, let's say, collaboration to be done with NGOs, then who will figure out, how will it be figured out, which are the let's say probable NGOs that can help out in these particular case? Who will decide that? None of that is explained in the judgment, right? So you can talk about this in critical aspects. Now, again, reasoning of the court is the essential reasons on which the judgment relies on, right? One very important and technical part here is the ratio descendendi. And ratio descendendi is something which a lot of students are confused with. I know I have been confused with it myself. It's one of the most difficult things to figure out throughout the judgment. But guys, trust me, once you've framed your issues correctly, it's not very difficult to get the ratio descendendi, because ratio descendendi is something that reasoning of the court, which if you turn upside down, I mean, if you negate that reasoning, the judgment entirely will change. So for instance, in this particular case, if I say that sexual orientation is a term which cannot be covered in Article 15, Clause 1 of the Constitution, which is what the Navtesh Singh judgment also said, and this court also said, and that is actually the ratio descendendi, then in that case, if I overturn it, then in that case, these people, this homosexual couple doesn't have any right, because sexual orientation is not being protected under Article 15(1), then that means that they can be discriminated against on the basis of having a different kind of sexual orientation. So this is how you figure out the easiest trick is to just negate the ratio descendendi that you have identified and then see its impact on the judgment, right? And of course, finally, the judgment ruling or the decision of the court. So this is a one-line answer or even a longer answer, as it is the case in this particular judgment, which actually tells you the answer to the claim that is made. So this is what a case note is, not a case analysis or a comment. When your case note ends, at this point, you have slight bit of idea about what the judgment is about. You have deconstructed the entire judgment to divide it, to clearly and indicate it in an indicative manner, put it in a very systematic manner, which you have clearly identified each of these individual aspects. So it is very, very important to understand the difference between a case note and a case analysis. So next time when you are trying to get a case analysis published, make sure it is more than just these parts, these reconstructed parts of a deconstructed judgment, right? Now let's talk about what a case analysis is. Now that's what I want to talk about. How to start? Then how to start with an analysis if this is simply a case note or a case summary? Then how do we go about doing a case analysis? So for that, I want to tell you a couple of things before I even talk about what case analysis or case comment really means. So first of all, as I said, that although you will be doing it to make a case comment, but read a judgment. First of all, from understanding the perspective of the legal system in which the judgment is made, because that has a bearing. For instance, if the judgment is made in a civil law country, then it doesn't have the similar kind of binding effect as it does in a common law country. So make sure you read the judgment, figure out all these aspects, legal aspects. Suppose if it is a judgment made by a High Court or a Supreme Court, it's going to be very different from a judgment made by lower court. Although you can analyze both, there's no denying that fact. But again, as I said, that you need to understand the implications. For that, you need to understand the legal system, jurisdiction, court of law where it is being propounded, right? Understand it now. Once you've read it and you've figured out these basic details, this next part is to understand from the point of deconstructing it, which means from the point of figuring out all these itty-bitty details. What's the relevant fact? What are the issues? And when you read it the second time, it will become much more easier for you to be able to figure out, because you might have already marked your important points in the first instance itself. Now, third thing is to decide whether a judgment needs to be analyzed. Not every judgment is analyzed. Not every judgment has to be analyzed. So you have to understand whether there is even a scope for analysis. Like if it is a judgment which is so clear that there is absolutely no point of further discussion. Everything that's required to be discussed has been discussed and laid to rest. Then what's the point of you discussing? Second thing is, if there's no new aspect, no legal aspect which is being discussed, then those are the things. But again, it's completely up to you. If you feel that there is some point to be discussed in detail with respect to a judgment, pick it out. Like for me, a simple thing was the judge's actions, which I wanted to talk about to show how transformative constitutionalism is being practiced in reality. So for me, that was important. And that's why I didn't talk about the merits of the case, to be honest, but the merits of judge's actions. So again, it's completely up to you how you approach it. The second point is where you start creating a note, which we have discussed in detail. So all of these things you already understand now, that how to figure out the relevant facts, how to frame the issues, how to go about summarizing the arguments of parties, how to figure out the reasoning, ruling, and from that ratio descendant of the case, and finally a judgment. So this also helps you understand how judge's mind is actually working throughout the judgment. Like, especially in cases where there are more than one judges which are giving their opinions, like in case of Sabarimala, when you read it Indu Malhotra's judge writing piece, her concurring opinion. So you will realize how different it was from the entire other judges that gave the decision. So to understand all those minor things, you need to make this case note. Now, another thing is with respect to for case analysis. Now, you see here, we just talked about the important parts, right? We didn't talk about the dissent. We didn't talk about other things that the court just talks about in passing, that is the obiter dicta, something that is not the real reasoning on which the judgment was propounded. And so if these are the important things, and then also some academic writings which might not have been discussed in the judgment, but which give a very fair point and a very important point of law sometimes, of what implications it will have on society and things like that. So material that might prima facie seem irrelevant for the purposes of a case note, but it might become very important for your case analysis. So think about that also while reading the judgment. Now, coming to what is case comment. Now, this is the most important aspect of this entire exercise. What is case comment? Case comments are short pieces of academic writing about judicial decisions. It's not summarizing the judgment, for sure. It is academic writing about any judicial decision. And academic writing is the research and writing which we talk about even in our research and writing course at Lawctopus. So that's an entire process which needs to be learned through in order for you to be able to figure out how to do this academic writing about judicial decision. It can be on the law that was propounded, as I said, it can be on any aspect of the judgment that you feel was important. You can talk about that how the argument of one party was not strong enough to be taken up as the winning party. You can talk about how the dissent was actually not something that should have been discarded so easily as it was. How you can talk about how the dissent should have been the actual decision. So any academic writing basically on the judicial decision, how you connect it with academic concepts, how you talk about its impact on the society by doing an empirical research, for instance. You can take the case analysis in any manner that you want. You can talk about it in any form of academic writing and just like take it as any other piece of law, legislation, provision, judgment, anything, and then go about analyzing it as you would go about analyzing or talking about or discussing or elaborating on any general academic writing piece. So the purpose of a case comment, again, don't confuse it with a case note. Case note is simply giving you a summary, but a case comment goes beyond that. And of course, it gives you more academic insight into the judgment because, for instance, as I talked about this constitutional morality that was discussed in Navtej Singh Johar judgment, you can go ahead and talk about how constitutional morality is not simply what was talked about in the Navtej Singh Johar decision, but it's much more and much beyond that. And you can explain that scope. So that becomes another piece of academic writing. So gain extensive knowledge on and around the case law. Now, this extensive knowledge here is not going to be restricted just about the case. As I said, that it is going to be beyond the case. Like if you're trying to understand transformative constitutionalism, then that's not just about the case, right? Of course, you're using the case to explain the concept, but it goes beyond the case law. It might help in future decision making. As I said, that dissent can become a future law. right? And when it becomes future law, do you think it will come simply out of no? Of course, it might come from a judge's own volition also, but a lot of times academic writers talk about the dissent, which should become majority decision later on, and how based on the dissent, the actual judgment is criticized. So it helps in future decision making, that when the later on the case is for here is up for hearing in the future decisions, then how the judiciary can go about changing its prior decision making. These are the most important points that I want you to understand and listen to carefully, because guys, research analysis can be about any of these points. Now, first of all, the most important thing is exactly critically examine the judgment, where you are talking about, where you are asking question to the judgment itself as to why the judgment is propounded the way it is. Second thing is predictive case comment. Suppose it is judgment which has not been propounded and still go ongoing, then in that case you can think about or read about the arguments of the party and try to predict as to which direction the court might go and on what grounds are you saying this. So predictive case comment is another type. Third thing is when you try to explain the implications of the judgment in the upcoming future. Like for instance, Buddha Swami judgment opened up many floodgates for future reforms, like, you know, having a woman's right on her own body because of bodily privacy, which was pronounced as a part of right to privacy under Article 21. Then it becomes a fundamental right. In that case, nobody can question that right of woman because it's clearly a part of right to privacy, which is pronounced as fundamental right. So in that case, what further implications can the case have on future? Another example is the passing of the legislation on transgender protection and prohibition of discrimination act 2019. I'm getting the exact name, I've used it, but that is another instance of what implication a judgment might bear when the judgment itself is giving you mandatory recommendation to go about doing this particular action that is required. Now you can also talk about implication in other areas and groups. Like for instance, if a particular judgment is being propounded only for homosexuals, particularly in this case, but implications can be on other sects also, like transgenders, trans men, trans women, or any other community that comes up in future. So not just that, maybe on any other marginalized section, because eventually it is saying that the dignity of these people or the basic fundamental rights of any individual are to be protected in whatever manner that you can, right? You can create a comparison between any case under discussion and other similar cases from India or from any foreign case law, because in 2020, this judgment itself discusses a very similar case that came up in US. So that is also discussed in this particular judgment. You can go about reading that judgment and then see how the reasoning varies of the two judgments and how this judgment could have had better outcomes or better decision. So again, create a dialogue in the existing scholarship or in the existing commentaries around or on the topic of the discussion that came about in the judgment. Last thing, again, just, see how, the judgment's result was anticipated. Like rights of homosexuals are being discussed since very, at least as far as I can remember, it goes way back to 1960s when this Pride Month itself was started with one instance in US. I don't remember the name of the city, but with one instance in US, a Pride parade was held in New York after that in the June month of 1966, I think. So because of that, like, see how, these particular changes were anticipated from that time onwards in the actions of people in scholarly writings, etc. And then see how the dots connected over the period of, let's say, 3 decades, 4 decades, and how today that transformation is actually being witnessed in the society. So connect those dots, see how historical advancement has taken, which led for us to come out with a judgment like this, right? Now, very quickly, finally, in just a couple of minutes, I want to explain to you this particular case comment that I wrote. And the first thing that you will notice is that I have not written as Sushma versus Commissioner of Police a case analysis. So again, don't need to necessarily say that it is a case analysis for it to be clear to the reader that it is actually a case analysis. But when you go about reading the introduction itself, the first thing that I talk about is a new era of transformative constitutional emerged when a High Court judge underwent psychoeducational session to deliver judgment from heart and not from the head. So this is another one line which again stood out to me because that was an effort that was made from on the part of the judge when he gave these directory and mandatory guidelines for protection of LGBTQIA plus community. So please understand that first thing is that you don't need to mention that it is a particular case analysis for it to come out as a case analysis. A lot of times the name is entirely different. Of course, you can say it. It's no hard and fast rule whether you can use it, whether you should use it, or whether you cannot use it, or whether you should not use it for it to be a case comment. The what you write in the after that particular is the initial heading is what matters. Like I started off with this judge's what he actually did, and then I talked about what the directions were, and all these yellow highlighted parts in this particular analysis are actually direct parts from this judgment itself. So the whole idea is to show you that how I actually used a lot of things from the judgment, but not in a very systematic manner of pointing out first facts, then arguments, then issues, then reasoning, and then the judgment. No, that is not what I did. What I did was cull out the most important things which made sense to me. So these are the parts of judgment wherever I have highlighted in yellow, which I used to show how transformative constitutionalism actually happened in this particular case. Now, these are academic writings which I refer to. The blue highlighted colors are academic writings which I refer to actually use the concepts which might have evolved in, let's say, an academic writing. And transformative constitutional actually originated in an academic writing by Professor Carl Clare in 1998, which is why I have given him due credit, which is why I have also given a proper footnote here, if you see. This footnote number 5, right? So I have given you due credit and reference to this particular professor who has coined the term constitutionalism, transformative constitutionalism. So this is what this entire exercise is all about, where you connect the judgment in whatever way you want to, and then talk about a particular academic concept. You relate it with an academic concept to enact in order to make an academic writing out of that judicial decision. That is exactly what I did. I tried to show in this particular comment that how judges psychoeducative session as well as his other actions, whereas he propounded those directions to to make actual efforts in destigmatization of the society, how they actually culminate into transformative constitutionalism. Because earlier transformative constitutional was simply about the legislation amendment and enactments, but here I show that how the actions of a judge can actually be part of transformative constitutionalism. So that actions actually emerge from the judgment itself. It's not an action which is done in a separate compartment than from the judgment. I have used a lot of parts of the judgment. I have used a lot of other things also. Like I have used a lot of other cases to emphasize my point on transformative constitutionalism, to emphasize how it actually can mean actual transformation in the society rather than actually just changing the law. So those are the aspects which I discussed in detail. I talked about how culmination of Navteej Singh Johar into transgender persons, Protection of Rights Act, this is the name, Protection of Rights Act actually is an indication of how there was an intent of transformation to be done in the society. But after this act also, this incident happened where the girls were being harassed by police, or they were not being accepted by their own parents. So then there is something wrong, right? The actual transformation, which is the intent of transformative constitutionalism, is not happening. That's what I talk about in this particular analysis. And you will see that most of the parts of this entire analysis are not really from the judgment, but from other pieces of academic writing, because I need to understand what has been said on transformative constitutionalism to actually relate it to what has been done in this particular judgment. So relating it and then giving out your own new argument about the fact that this can only happen in the society when it is propelled by actual actions of public figures like the judge of the High Court in this particular instance. So I hope I was able to give you some insight on case comment, and I've talked for a very long time. So Sanya, over to you.
Wow, thank you so much for such a detailed explanation, Varshika. It was an eye opener for me as well. So, guys, this is the difference between you simply skimming through an order, a judgment, versus you actually going through it page by page. Before we move on to case brief, I would just like to take a minute to address this particular question that many of you are having. That do we have to go through every page, even if it is hundreds of pages long, even if it is thousands of pages long? How do we do it? It gets boring after a while. Well, see, guys, it does get boring when you don't see any sense in it. When you read to actually understand what happened, it starts getting interesting. You have to give yourself some time, and law is so diverse. There are so many judgments, so many orders in almost every part, every subject that you can think of under the sun. Figure out what interests you. If it's bitcoins, if it's finances, if it's same cheating cases, or if it's criminal cases of murder and rape, or if it's constitution, anything under the sun that interests you, start there. Start reading the judgments that pique your interest, that make you think, okay, yes, I would like to know what is going on these days. What is the law of the land on this particular issue? Tomorrow, say if I have to do something about it, how to go about it? That's the very least, that's a very small step that you can take. Another thing, there is no shortcut. There is absolutely no shortcut. The analysis, the note that Varshika just showed you, and the analysis that followed, and the comment, and her own interpretation of this particular order, the entire theme of transformative constitutionalism, all of that could not have happened had she not really gone through the entire order, connected the dots between what she had studied, between her research, between everything else that she delved deep into, and try to connect that with what was held in this particular case, along with the facts of the case and the legal issues, and combining everything to come to a conclusion of what she thinks of it. So that's her opinion, her analysis, the ability to really understand what was going on or what could be better. There was another question that we had, where somebody said that, okay, so why do we how do we criticize a judgment? Isn't it not a good practice to follow, that we shouldn't be criticizing a judgment that we are bound by? But law is a living creature. It evolves with the society. It will never evolve, it will never serve the needs of the society if it doesn't catch up with the society. We are the society, just like it has been said in the order. We are the society. If we don't question, if we don't express our opinions and what we think could be better, we will not evolve. The law will not evolve. So critical analysis, the right to dissent, and the right to speak your mind in a logical manner with reasoning backed by your research, everything comes into play to really make sure that you're putting your point across, and not just criticizing something just for the heck of it, but really understanding it and then talking about maybe how it could be made better. So everything that Varshika covered just now, and there was some particular questions for her that will be taken by her in the Q&A box. We talked about you analyzing this order, you understanding first what is in the order, and then having an opinion, making an opinion with your research, with your understanding, connecting one thing with another, and then making your case analysis, case comment, case note, case summary. All of those things can be used interchangeably right now at this point. Now, a lot of the times you come across such fancy words, there's a lot of legal jargon, there's a lot of repetition, and you don't understand those things. So you're like, okay, I can't read any further. The more you read, I would suggest that you make a list of all the fancy phrases and all the difficult words that you find. It will help you improve your legal vocabulary, which will come in handy for your academic writing, which will also come in handy for your legal drafting later. When you're formally drafting a document that has to be filed in the court of law, it has to be well presented and it has to be well worded. So, to be able to do that, you have to know those words anyway. So if you come across anything difficult, you try to maintain a list of all of those things that are difficult along with their meanings. You go through that list again and again. It will become easier to read. In the beginning, reading anything for the first time is always difficult. It takes a lot of practice, a lot of time. The more you read, the faster your speed will become. Another question was that where can we find these orders and judgments if they are not reported yet? Well, you can go to the court's official website. You can search for the court order, you can search for the judgment, and you can download it from there directly. That's the most reliable copy there is. If you still can't find it, then you go to live law. Live law these days has all the documents. There was this recent joke that was cracked by Justice Chandrachud in one of the hearings. He said that we don't have the document yet, but maybe live law does. So don't know where live law gets all the documents from, but they do, and they're reliable also. So you can go and you can download the judgments and the orders from that website also. But the idea is to make sure that the copy that you have is an authentic one, it's a reliable one. That is why we don't always recommend Indian Kanun, because Indian Kanun is much like Wikipedia. Anybody can edit it, anybody can change the order, although it is a good way to at least get started, because it's a free resource for a lot of the law students. So you at least know that there's a judgment like that in existence. But to read it completely, I would suggest you go to the website, the court's official website, and you download the order or the judgment from there. Another thing that you can do in your free time is to go to Supreme Court's website and check all the latest judgments. They upload all the latest judgments over there. So you can at least have an idea of what is going on. There are weekly roundups of live law also. Every week they have these 5-minute videos where they talk about what were the main orders of Supreme Court in the past week. So that helps you keep track of everything. Now, that is one thing about keeping track and reading and developing a habit of reading. Another way to do it is also to have a group of friends where one person can read a judgment and they can prepare a case note or a case analysis and present the case to the entire group. And then you can do it in rotation, just like we have book clubs. If you can't read it completely, if you think you'll be able to better understand it by listening to it, you can also turn it on audio mode and you can just listen to the judgment. The idea is to keep yourself around it so you can absorb it and try to think about it. Now, building on what Varshika just explained to you, she talked about case note and she talked about how to know what exactly is there in the judgment before you start actually analyzing it. Sorry. So, what you do with the case note, the way she presented it, was for you to understand, okay, now this is what is there in the judgment, and now I have to, analyze it or share my opinion on it. What we do in case brief is that we don't just make sure that all the points in the judgment are there in our brief. The important points, we paraphrase them. Sometimes some points cannot be paraphrased, as I will be discussing with you just shortly. We put those points in our brief along with their corresponding page numbers and the para numbers that can be found in the judgment. Now, when you enter the legal field, when you start practicing as a lawyer, as a young lawyer, as a fresher, a newbie, you will not be expected to recite the legal provisions as they are, to reproduce them, to say, okay, no, section 360 of this particular act says this, I'll be able to just recite it out of my memory. That may be impressive, sure, but that will not be expected of you. You will be, however, expected to know what's right in front of you. Now, I don't know if I've already discussed this with you, but when we talk about art of advocacy and when we say that, there is an equality of opportunity in litigation, particularly because, and this was said by Kapil Sibal, senior advocate Kapil Sibal, when he was discussing art of advocacy, because your opponent, and the judge, all three of you have the same file. You have the same documents. It is mandatory for all the parties to give all the documents before they start arguing, before they start making their case. Even when we are citing a judgment in our, say, plaint, or in our, written arguments, when we are saying that this was held in this judgment, we have to provide a copy of the judgment to the judge, to the opposite party. If there are more than one number of judges, then we have a copy for every judge. And we make sure that they know just exactly what we are going to say by already writing it in our written arguments in our file. The reason is that this is the law of natural justice. All of you have to know where all of you stand. It's what you do with the raw material that matters. That is why there is equality of opportunity in litigation. So you will have the same file, your opponent will have the same file. And what you do with that file, how you present your arguments, is all that will matter. So, how well you know your file, how well you know your judgment will be step one. If you know it inside out, if you know just exactly what is where, you have a mental map of all the important ingredients of that particular document, at the time of making a case in front of the judge, you will be definitely able to support all of your contentions in a well prepared manner by the help of your brief, by telling the judge, your lordship, if you may please open page number so and so, para number so and so, please refer to this paragraph. I'm going to read out this paragraph now. And then the judge will think, okay, yes, now I know what this person is talking about. So the judge will also not get angry. The opposite party will already know, you will already know what they're going to cite, what they're going to say. And then you will also have the time to prepare for the rebuttal. Now, I am going to, so just like Varshika showed you how she read the order, I am going to show you how I read it as well. Before I show you the brief. So I'm going to share my screen. Varshika, can you please let me know if it's visible? Okay, thank you. So again, this was the order, guys, and I will not go through the entire thing again because Varshika has already done that. Now, I have highlighted some bits and pieces, but the way I read it for the first time is that I annotate. How do I annotate? I put comments of all the things that I think are important, and these are my comments. So every paragraph that I was going through, the things that I thought were important. And yes, it takes time for you to understand what is important. It also depends on the purpose of hearing, on the purpose of the argument that you're going to make, the point that you're going to justify before the judge, saying that, yes, this should be held in my favor because this. So then you know what to look for in the judgment once you've researched and you've found the perfect judgment. So you'll understand better what the important point is. But in my first reading, in my first cursory reading, I do not think about what's important, what's not important. I think about what I will be expected to know before the judge. I should know the paras and the page numbers. I should know who are petitioners, what are the parties. I should know what happened. Brief facts should be here. Again, if you see all of these comments, they are paraphrased and they always will have the relevant para number and the page number right over here. Now, these are the comments that I made in my first reading. Then I read it again. Then I highlighted what I thought was important. We can, just see if it helps you, because If I'm looking for a particular paragraph, a particular point, a particular important thing that I really want to find, I can simply go to that particular comment and that particular page will open and I'll be able to read through it. So that's why it's easier for me. And again, this is my way of doing it. This is not the only way, and you can always see what works best for you. The idea is to get an idea, first of all, what the case is all about, what are the points that you should keep in mind, along with their relevant location in the file. So you can click on the comment and you can directly go to that particular important page or the paragraph number. Now, once I have read it once, I have put in my comments, I will read it again. I will read my comments again. And that's the time when I will start making my brief. Now, somebody has asked me to zoom in a little bit. So I just wanted to show how the comments are, where the comments are. I'll share it again, but don't bother reading all of that. It's not for you to, read all of that right now. It's just to indicate that this is something that you can also do. So if I just zoom in, let's see. So this page, paragraph number 4, page number 8. So page number 8 to 13, paragraph number 4, order dated so and so, I've already mentioned in my comment here. So this is annotation. So whatever I think is important or significant that I can use in my brief later, I put all of that right here. So the second reading that I do, I have to go through these relevant paragraphs because I know that, these are the ones that are important for my arguments or for me to understand the case. So I just go to these comments, I read these comments. Instead of going through the entire judgment again, I can go through the comments and I can start preparing my brief. So this is only for that purpose. It's just another way of doing that. So I don't prefer highlighting a lot. And also in our files, we put a lot of sticky notes and post-its and everything, but it gets hard to even read through the post-its and flip through the pages again and again. But in the virtual era, in the digital era, when we have the document right in front of us and we can jump to the exact page number and the para number very easily, so these comments help in that. Now I will share with you the brief that I have been talking about since forever. Now, see, the judgment was 107 pages long, as all of you must have seen already. And this brief is 3 pages long. And it contains everything that the judgment contains. Now, how to do that? How I did that, my process is something that I will walk you through bit by bit. If my video is lacking or my voice is lacking, let me know. If my internet is unstable, Varshika, please let me know. Okay. So the very first thing that you do is you identify the case. You write the cause title. So you mention the name of the court. You mention the name of the case. You mention what type of case it is. In this case, it is a writ petition. It's a civil writ petition. You mention the number of the civil writ petition. Now, the number becomes extremely important in cases to find their orders, to find the judgments online, to track them, and also to make sure that, if you have any further information, if you want to update your note later, then you will be able to do that with using this number. You go to eCode's website, you go to the official website of the High Court, and you're able to check the order or the development in the case by using this number. So it is very important. And then, you write what this is. It's a brief, and here you write quorum, because sometimes it is important for you to understand if it was a single bench order or if it was a division bench order, because in India, we also follow LBR, which is the larger bench rule. So the larger bench, if they rule or overrule something, their decision is binding over the smaller bench. So that is why quorum also becomes important. This was a single bench order. Now, if you see over here, I've put as my comment the parties. Now, if there are more than one parties, if there's more than one petitioner, first of all, always remember to use the proper nomenclature. It is a petition. So the one that will be filing the petition will be the petitioner, and the one who against whom the petition is filed will be the respondent. And there can be multiple parties. And oftentimes, multiple parties are represented by multiple advocates. And the parties are also referred to as petitioner 1, petitioner 2, respondent 1, respondent 2, so on and so forth throughout the order. So to make it very clear who is who, you put the details of the party right here. Details as in, I don't mean you put the addresses, phone numbers, email IDs. You only put the names. So P1 is petitioner, P2 is also the second petitioner. So Sushma and Seema. Then R1 is DGP, Director General of Police. R2 is CP, Commissioner of Police. R3 is Commissioner of Police. 4 and 5 are the parents. So 6, 7 again the inspectors. And then these R8 to R24. These respondents were suo moto added in this particular case by the judge himself, because he was pronouncing and issuing some guidelines that were applicable and were to be followed by these respondents. So if you go through Article 226, you will be able to see that these, if you are pronouncing an order for somebody to follow, which is a mandatory or a directory order, then they also have to be made parties. So a writ of mandamus was issued, and which is a continuing writ and continuing mandamus. And so these parties also become important. Now, if in case, let's say I am in the court and I am talking about R4, R5, who are the parents, and the judge just asked me who is R4, R5, and where are they, and things like that. And I don't remember, because a lot of the times the hearings are also spread out, they'll happen 3 months or 4 months down the line. You've read it once, you won't really be able to recall just exactly what happened. So this becomes a good refresher also for you. Now, if I have all of these parties right over here in front of me as a comment, I'll be able to just read through my brief. So that is why it's important to mention your parties also, who's P1, P2, R1, R2, so on and so forth. Then you have the prayer clause. Now remember, prayer is the very reason why the court was approached in the first place. So prayer is the relief that you're seeking from the court, the reason why you're there, explaining all the facts, all the sequence of events, everything that happened, along with the application of law. You come to the concluding paragraph, which is the prayer paragraph, where you ask, okay, I want you to do this for me, to put it very simply. So the entire petition and everything else has to be read within the context of the prayer. It becomes extremely important to know the prayer. And whenever we are talking about something extremely important, something that we cannot afford to change the meaning of at all, we do not paraphrase it, not even in our brief. The reason I've been able to put all the 100 pages into the 3 pages that you see right now is because I paraphrased whatever was said in the judgment. I eliminated the legal jargon, the beautiful language, the complete sentence structure, and I put exactly as much as you needed to understand what is important, what is being said. So I am putting the bare minimum right here. So I'm paraphrasing, I'm simplifying the language, I am changing the words, but I'm not changing the meaning. And please remember that you are not giving your opinion at all when you're writing your case brief. You're not saying what you think is right or wrong, or what you think connects one with another. Yes, you're applying your mind in order to paraphrase and understand what not to paraphrase, and understand what the judge may ask and what you need to be prepared with, but you are absolutely not giving your opinion. And this is not to be filed in a court of law, this is not to be submitted anywhere, this is only for your reference and maybe your senior's reference at the time of hearing, so you can be prepared. So the prayer clause, as I told you, is very important, and that is why we do not paraphrase it at all. So the prayer is at page 5 of the judgment, and it has been reproduced as it is, and we have also reproduced it as it is. It was a writ petition filed under Article 226 of the Constitution to issue a writ of mandamus directing respondent numbers 1 to 3. See, that's why this comes in handy. 1 to 3, who are these respondents? to inquire with the parents of the petitioners and instruct them not to interfere with the life of the petitioners, and consequentially to grant the necessary police protection to the petitioners. Now, this was the prayer clause given in your petition, in your order, and this is how I reproduced it verbatim over here. Then you go on to the summary of the order. You can use a table. It is not mandatory. I do it because it makes reading it easier for me. It makes understanding it easier for me. You put the dates in one column. You put the particulars, what happened on that particular date, in another column. Along with, I cannot emphasize this enough, always with the relevant paragraph and page numbers, as you will see here. Now, even though this doesn't mean that you go para by para, that you have to paraphrase the first paragraph of the judgment first, you have to paraphrase the second afterwards, not like that. Once you've read everything and you've annotated, you've put your comments, you will know what the sequence of events is. So, in your brief, always be chronological. Talk about what happened first, then talk about what happened after that, and so on and so forth. It gives a logical coherence to you, for you to understand the case, for you to make your point even more comprehensively. You must know what happened in a logical order. So the very first thing,
Excuse me,
yes,
Sanya, could you increase the size of the screen, please?
yes, sure, I'll do that. I'll do that. So is it better? Varshita, is it better?
Sanya, I think we can go a couple more points up. Yes.
Okay,
Thanks.
great. So the very first date that I've mentioned over here is 9th February 2021. Now, why I've mentioned this date first was because it was on this day that the petitioners actually left their homes, which started the entire ordeal that led for this particular case to be filed in the first place. So it was on 9th February, which is the very first important date, and where I've written P1 and 2, a lesbian couple aged so and so fled from Madurai to Chennai on 9th February so and so. And I've mentioned, if you have the judgment open in front of you right now, if you go to paragraph number 4 at page number 9, you'll be able to see all of this. You'll be able to see that this paragraph talks about this. And para 5 of order dated 29th March 2021 also talks about this. So if there are multiple paragraphs talking about the same thing, then I've mentioned that thing once and I've referred to the paragraphs that mention those things. So instead of repeating everything unnecessarily, I have just put everything in one place. Then what happened? The missing girl complaint filed by R4, R5. Here I can see who R4, R5 are. Then P's parents before R6 and R7, police. Then 2 FIRs registered. Para 2, page 6, 7. P1 and P2 supported by NGO PCVC. Now, if you've read the order, you'll understand that the judge also recognizes the importance of these NGOs, how significant they are to protect the community, because they provide them shelter, they provide them assistance, financial assistance, emotional support, and that is why these NGOs should also be enlisted. That was given in the guidelines later. So this NGO supported the petitioners also becomes important in this judgment. And just in case I don't remember what the full form of the NGO is, I've put it here: International Foundation for Crime Prevention and Victim Care. So if you just go through this particular column, you'll be able to understand the facts of the case in a very brief manner. And you'll also be able to locate them in your file. Now, after that, I go to 15th March 2021, which was the date when this petition was filed. Now, you will think that this particular date is not mentioned in the order. That is because I took the number of the order. I went on the official website of Madras High Court. I checked the case status. I wanted to know just exactly what the sequence of events was. So I checked and I found out that on 15th March 2021, the petition was filed. Now, all of those things that seem very small to you, that seem like, okay, why do we need to know all of this? Those things can always come in handy at the time of hearing. You never know. So you must be prepared, always prepared with a sequence of events so you know what the judgment is all about from start to finish. You're able to really understand it. And over here also I've mentioned the paragraph number, page to number, WP file, and so and so. Now I have paraphrased it. The way I've done it is that I have used abbreviations. Instead of writing petitioner again and again, I've just used P1 and P2, R1, R4, R5, so on and so forth. And instead of writing complete sentences, I've used hyphens, I've used active voice. So I'm not saying that the couple, the FIR was registered by the parents. No, I'm saying two FIRs registered. I'm not saying that the couple found it very difficult to live with their parents, so they had to flee their hometowns, and then they came here, and now they're fending for themselves. All of that is understood, but I don't need to know all of that to really understand the case. So I'm simply saying lesbian couple age is important because we are saying that they are adults. So we need to know their ages. Fled from Madurai to Chennai on so and so. So when you use active voice, when you use abbreviations, when you shorten the sentence, you don't change the meaning of what is being said in the judgment. You are only rephrasing it to make sure that everything fits, concisely in a logical, in a coherent, and in a comprehensive manner. Now, similarly, then we go to 29th March 2021, this order was pronounced. The main things that were held in the order, I've highlighted, I've put in bold that the FIRs were ordered to be closed against the petitioners. This is important because let's say I am arguing a case and I'm saying that my clients are also similarly situated. They are also a lesbian couple and they are adults and they fled their hometown, and these guidelines were, and they've been harassed by the police ever since this case was the FIR was registered against them. So I can simply say that this particular judgment came where guidelines were issued for the police, and the police was asked not to harass them, and if they're adults, consenting adults, then you just close the complaint. And then I can say that on page number this in this, para numbers this in this judgment, the judge ordered closure of the FIR. And then if I want to refer to the guidelines also, I have the guidelines right over here. So I can just say that para number 43, page number 88, if you just go, if your lordship would be pleased to open para number this, page number this, and the guideline for the police will be there. Now the guideline for the police is here, which has been paraphrased by me. But I am aware that the judge may ask me what exactly the guideline says. And when I am not the authority on something, if there is a legal provision, if there is a particular guideline, a government notification, a certain stanza or a paragraph from a judgment that expresses something that has been held or something that is the law, then I cannot risk changing the meaning of that particular thing. And I cannot say that just because I am saying it, then I am the authority on this. I have to reproduce verbatim just exactly what the authority says. So when the judge asks me, if the judge asks me, what is this guideline? I have also reproduced the guideline right over here in my comments. So here you will be able to see this para A, the first guideline on page number 88. The police, on receipt of any complaint regarding girl, woman, man missing cases, which upon inquiry investigation is found to involve consenting adults belonging to the LGBTQIA plus community, shall upon receipt of their statements close the complaint without subjecting them to any harassment. So this is verbatim the guideline. The judge can read from the judgment. I have put it in my brief so I don't have to flip through the pages of the judgment again and again, and I can simply read from my brief what the judgment says. So that is when these things also come handy. Now let's go back to the order, 29th March. So we are going chronologically. 29th March, the important things that were held, I have mentioned in this column. Again, after that, 28th April 2021 was another important date. Another important order was held when Miss Vidya, who is the counselor, who was asked to prepare a report, she prepared a quadripartite report. So I've written over here, it's a quadripartite report. Instead of writing 4 parts, the report is divided into 4 parts. I replaced it with one single word, and that shortened my sentence significantly. Although you are advised to use simpler words to make it more comprehensive and to understand it easily. But if there is these words that you know of and that you can find, you can use those words also while paraphrasing, because ultimately it's for your reference and for your seniors reference. You should be able to make sense of it. So what did the report, what did these parts carry? I've mentioned here, this part was for him, this person, this part was that person. And then I have also mentioned a brief summary of what the report carried right over here in my comments. And then I have reiterated that the judge seeks a psychoeducation session with Miss Vidya. Now, this also becomes important because this is the first time a judge has done something like that. So, I may be asked at the time of hearing if I'm making a point saying that, we should be more sensitive about this. And in this judgment, also, the judge himself underwent therapy, and the judge propagated the need for sensitization in the guidelines also, then I must be prepared with all of this, that on this paragraph number you'll see this, on this page number you'll see this. Then 7th May 2021 was the report of Miss Vidya that was filed for the judge. So what the judge went through when he went for the therapy, and he wanted to maintain absolute transparency, so he extracted the report as it was. And when that happened, a lot of the things cannot be paraphrased. Although there is a little bit of summary of what this report was all about, some things that are important have been reproduced as it is. For example, I am the society with all the misconceptions present. Now I am working through it and engaging the process of unlearning. So it is me who needs to convey this understanding to the rest of the society that stands where I once stood. So I've written this, reproduced this as it is, just in case I am to persuade the judge that we need more sensitization programs. So I can just read it out from my brief. Similarly, what happened on 21st May, and then so on and so forth, every single paragraph, page number that is important has been mentioned in the columns. If I need to talk about violation of articles, so and so articles of constitution, by against discrimination against the people from the community of LGBTQIA plus, then I have also given a chronological order of these judgments. So in 2010, Nas Foundation judgment was passed, which held this, and that was reversed by Suresh Kumar, and after that Navtej Singh Johar judgment came about. So all of that trajectory has been traced by me right over here. So when you read it in the judgment, it's spread out all over the judgment. But if you read it comprehensively over here, you'll be able to make more sense of it. And then you talk about Nalsa, which happened in 2014, and Navtej Singh Johar is an important judgment. So 2018, what was the important aspect of that judgment that has been captured here? Ideally, I should have these kinds of briefs prepared for all of these judgments as well, if I want to be even more prepared. And then you go to the mandatory and directory interim guidelines issued, page numbers, all the guidelines are here without being paraphrased, and here they are paraphrased. Now we are running a little bit short on time, so I will just quickly tell you that you have to make sure whatever you're paraphrasing doesn't change the meaning. And after that, what you don't have to paraphrase is also something that's absolutely clear to you, and you are putting all the information there in your brief along with the paragraph numbers and the page numbers without missing them out, and always checking if they can be found on the same place or not. You keep updating your brief. For example, this is a continuing order, so the next date is in August sometime. If a new development happened, I can update my brief here only. What happened on that particular day? I can add another column. There are various ways to do it. Of course, we can't discuss all of them right now, but we'll talk about them towards the end when we talk about our course on briefing case files, making briefs on case files. So that's also similarly situated. Now with this, we've shown you a case comment, case analysis, and case comment, case analysis, same thing, and the brief that you need to prepare. So we just come towards the last part of the session, which is for us to summarize everything that you've done till now, you've heard till now, and we're going to share a PPT with you to do just that, so that you can retain all the important information. We're going to recap everything in the PPT. So I hope you can see my screen, everybody.
Yes,
So
Anya, it's visible.
great. So our session is about reading judgments, differentiating between case comment and case brief.
Sanya, just a second, if I can take a minute. Guys, just bear
Yes.
with us for 5 more minutes, and then certificates we will talk about. We'll come to the certificates, just 5 more minutes, so that we can sort of concisely put everything together which we have discussed. Otherwise, it's not going to make much sense to you as to how to differentiate between the two. So just give us
Again, yes.
minutes, and yeah.
And remember the purpose why you do what you do.
Yes.
Just like, if we just read the judgments to pass our exams, we won't understand anything. If you just attend this, this session just to get your certificate, it will not have any impact. So
Yes.
please understand for the sake of understanding. Now we covered all of this today: how reading judgment properly solves basic classroom and courtroom problems, making a case comment with special focus on referencing, case brief with focus on paraphrasing, and we are going to talk about the key differences uh, in this particular presentation. Some points about referencing are going to be covered by Varshika. Over to you, Varshika.
Right. So guys, if you have noticed, in the case comment that I showed you, my case comment, if you have noticed, there were like, I think 23 references that I'd cited in the case. And guys, understand that though referencing is not very important or even required for case briefs, but if you're writing an academic piece, you are, if at all you're intending to get it published, acknowledging the original sources from where you have use the content, the idea. Remember the Professor Carl's definition, which I had cited in the initial beginning only, based on which my entire argument is based out of. So referencing is very important. How do you do referencing? First of all, I want to talk about why referencing, because there is an academic integrity. You cannot use somebody else's arguments and pass it off as your own. So no. Second thing is to cite the original source, to be able to track the original source from where you have derived, or to be able to tell the reader that this is where the reader can locate the original source from where I've got the essentially the citation. Again, Professor Carl's definition, his 1998 paper was cited, so you can go read the original document if you wish to get a better and deeper understanding of transformative constitutionalism. Last thing about referencing is, if I say what transformative constitutionalism is, simply my definition or my understanding. Currently, I'm not really that big an established scholar, or even let's say I am not a judge in myself. I'm not a Supreme Court in myself. So my words, as much as they are my own original thoughts, they might not hold as much persuasive value as the wordings of a Supreme Court decision or the law or any established scholar, especially the esteemed scholars in their respective fields, will hold. Sana, can we go ahead? So again, one very important aspect of referencing is to avoid plagiarism. Again, if you're passing off somebody else's work as your own, that is plagiarism. It's actually stealing, because you are not giving due credit to the person who came up with the original thought or the original contribution which you have used to make your argument. So if you see in a case, analysis or case comment, because it is an academic piece of writing, you have to necessarily give that particular recognition or the due credits which needs to be given to avoid plagiarism. Also, if you do plagiarism, guys, understand that there are serious consequences to plagiarism, starting off with not getting published, being blacklisted by certain publications or even journals for that matter. In schools, if you plagiarize your content for, let's say, thesis, etc., you might be rusticated. You can be like, you will have to repeat a year or something like that. So why do that? So just make sure that you are very thorough with your research. You are not plagiarizing unintentionally also. And in case it so happens that there is some unintentional plagiarism that just follows without you knowing it, so make sure that you do a thorough review. And in that review process, make sure you're running a quick plagiarism check also, in which you can see which parts are plagiarized, but which you have given due credits for. So make sure that you are running a proper plagiarism check, and reviewing that plagiarism report is very important, because if you have borrowed some idea, it might still show as plagiarized, but if you have given due credits to it, be it whether you're using it verbatim, then you use the quotes and then cite it. If you're paraphrasing it, still after paraphrasing also, guys, understand it does not become your own original contribution. You still have to give due credits wherever they have to be given. So after paraphrasing also, please make sure you're citing it, otherwise it will show in plagiarism check. And finally, of course, repair your work. If you think that there is something which is plagiarized, then make sure that you are changing it, right? So Sanya will talk about paraphrasing, just quickly summarizing it.
Thank you so much, Varshika. So paraphrasing is a way of saying the same thing in different words, as we just saw. Some tips that you can keep handy before paraphrasing. Read the law, read the entire thing, get the context, understand what it's all about. Do not skim through. Actually read and then identify what is important by looking at the purpose of why you're reading it. If you're looking for an argument on a particular issue of law, and how to identify that will be in your judgment, because you will be using that judgment to support your argument. So keep the argument in focus, identify the important points accordingly, organize all of your points in a chronological sequential manner. Do not go haywire just because they are being repeated multiple times in your judgment or in your file. Doesn't mean you have to do the same in your brief. You can keep it short and simple. Then, while paraphrasing, some tips: use active voice, use abbreviations as we just saw, and use simpler words. So you can replace 3, 4 words into one word. Try to aim for that. Use active voice instead of saying, say, like the little boy was chased down the street by big bullies. You can just say big bullies ran after the little boy, or you don't even have to use big or little, because those things are qualifiers and they're not important for you to understand the point right now. So always keep the purpose in mind. Use active voice, use abbreviations, use simpler words. I'm going to share a reading resource with you in the chat box shortly to help you understand more how to paraphrase in legal world. After paraphrasing, make sure that you have restated everything, that you've not changed the meaning when you're paraphrasing. Recheck that you're referring to the paragraph numbers and the page numbers, and the point that you're referring to a certain page number, that point can be found there only. You have not mixed up the information. So rechecking is very important. Again, the same thing. If you find any anomaly, if you find any mistake, repair it. The time given to revision is often underestimated. It's very, very important to always revise before you think that, okay, you're done with that. When not to paraphrase. So these are certain situations. In essence, I will tell you that you do not paraphrase when you're not the authority on the subject. When you are actually talking about something that has been held by a particular judge, an order that has been pronounced, a notification that has been released by the government. When the judge asks you at the time of hearing, they will not ask you what you think of it or how you understand it. They will ask you what this law says. For example, if section 2K was mentioned of Transgender People's Act 2019, Section 2, Clause K was mentioned in the order, and you have to tell the judge what that section says. You cannot just say what you think the section says. I'll say that it defines transgender persons, but what exactly is the legal provision is something you'll have to open the Bare Act for. And that is why we reproduce that provision, we reproduce those parts exactly as they are in our brief, so we don't flip through multiple pages of different documents. So know when not to paraphrase. Again, now key differences. Varshik, I'll need your help on this. Now that you've seen case brief also, and you've seen a case comment also, I am sure you must have been able to identify some differences between our approaches, between the purposes, the utility, and how we made a case brief and a case comment today. So we're just going to recap those differences for you. The very first difference for case brief is that you locate what is said where. That is actually a map, a mental map, or a road map that helps you navigate the judgment. There is no opinion in it. And in case comment, on the other hand,
And in case comment, it's not about what is found where, but it's about what do you do with what is found in the judgment. So then what is the next step? Like, what are your opinions? What is your comment? What is your critique on it? What is that place where you intend to take that judgment now that it's pronounced? So that's a step you are done with the case note.
absolutely. And in a case brief, we do not have any footnotes or endnotes. They are for our reference. We are not trying to beautify or lengthen them unnecessarily. We are trying to keep them as short as possible, only for our reference. So we do not put any footnotes or endnotes.
Right. Again, in case comment, as I said, it is an academic piece of writing. Please treat it as one. It's not a mere summary of whatever is being said. However, if you are using what is said in the judgment, make sure you are giving due credit to the judgment also, even when you are actually analyzing the said judgment. So if you notice in my case comment, I have written actual paragraph numbers of what is said where. Like the judge said that I am the society. So it was on paragraph of the judge or page 32 of the judgment. So I actually denoted that page. So it helps the reader to actually locate the original source and to exactly locate the original source.
I would just like to clarify here that footnote and endnote is to locate the original source. So the paragraph you mention over there, the style and the way you cite it is different. The paragraph page numbers you mention in case brief are very informal, and they are for you to locate the points in the judgment, not to locate the original source of it. So you have to understand that difference very clearly. There is an informal tone. So as you saw, I used abbreviations, I used hyphenations, I used incomplete sentences which were not even grammatically correct at all times, but they made sense to me. At the same time, you have to keep in mind that you're not using SMS language, you're not using LOL, ROFL, and things like that. Abbreviations which are acceptable, which are understandable. WHO for World Health Organization, MHA for Ministry of Home Affairs, and CWP for Civil Writ Petition, things like that. Those are understandable abbreviations. So always, although there is an informal tone and it is for your reference, you still have to maintain some semblance of decency. And in case comment, on the other hand,
Right. So in case comment, your language is your weapon, actually, to be honest, to be able to convey what it is that you want to convey. And I am not propounding that you should use very fancy language. Some of the students had this concern that my English is not very good. My English is not very good. But that's not the point of academic writing. The whole point is to be able to put across what you want to say. So language becomes an essential part of being able to convey something that you want to in very clear and precise terms. So language matters, but not as much as we make it to be. The whole point of language is to be able to clearly convey what you want to convey, but grammatical errors should not be there. That's definitely there. Grammatical, simple formatting errors, all of that needs to be taken care of.
right? And finally, the purpose, the utility of the brief is at the time of hearing. So you can substantiate your arguments with exactly the location of that point in the judgment or in the document, in the file that you're referring to. So to make it easier for you to make an argument at the time of hearing is the main purpose for the brief. On the other hand, there are various purposes for case comments, as Varshika will tell you.
Yes, like a lot of things. First of all, we discussed this before also, like to better understand what the law is about, to better understand the law under discussion in the case law, to better understand application of law to the facts in a given circumstance, then to be able to put yourself in a situation to take that case and move ahead with it. What is the next step after that? What are the implications of the case? What are the possible that could have been for the case, whether there is a need to review the judgment, then on what grounds, anything that you want to talk about, how you connect it with conceptual learnings of your classrooms in law school, of whatever is going on in the society as to how it is going to be implemented. Like I gave a couple of critiques of this judgment itself, the directions itself, that it is not clarified that in what duration those actions have to be taken, especially the recommendatory ones. So you can think about it on those lines as to is it enough or what next is required.
Absolutely. So those were the key differences that we want you to keep in mind going forward. Now, what to do after this session? There are a lot of things that you can do to keep the momentum going. Some of them are upskill. Keep learning, keep growing. If you identify something that you don't understand fully, you also identify the things that will help you understand or appreciate that particular subject matter. So you upskill, you look for certifications, you look for courses, you look for your own research. Peer learning is a very, very, very important tool. Like I told you that, one of the things that you can do is form a group amongst yourselves, your friends, and all of you can decide to read judgments collectively, like we do read books together sometimes. And there are different ways of reading them. Take your own time. When you're reading it for the first time, it will take time. You will be slow. But the more you read, the more you practice, the faster your speed will be to read. And the more you'll be able to locate, okay, so this part will have this part will have this part will have this. And the more understanding of how a court proceeds with the case and comes at a conclusion, which is actually the driving force for every lawyer to actually persuade the judge to come to a conclusion that's favorable to our clients. So, how that happens will be more clear to you when you read different judgments from different subject areas and you create a group of people with similar interests and read together. And practice and persistence, of course. No substitute to hard work, guys. No substitute to practice. These are all the skills that you're developing. And the more you practice, just like I don't know if you've seen Friends, but just like Joey learns how to play guitar, first you get familiar with the chords, and then you get handed the guitar, and then you keep practicing till you finally learn to play somewhere close to Eric Clapton. So you need to continue practicing, and persistence has to be there. These might sound like cliches, but that there's absolutely no substitute, and they're cliches for a reason because they work. So please remember that. Now, some options that we have for you on how you can upskill on the skills that we discussed very briefly today. Varshika and I tried to condense these huge, humongous topics into 2.5 hours, and that is why we're still running short on time because there's so much more to say on this. I will just tell you about litigation basics. So this is a course that I co-developed and I teach at Lawctopus Law School as a learning manager, also as an instructor. Also, it talks about how to read case files. So just like we talked about reading judgments, we also need to be prepared with our case files. So how you read your case files, how you prepare your brief or the note on the case file, so you're prepared with the case at the time of hearing. We also cover stages of civil proceedings, criminal proceedings. We talk about eCourt's website, how to navigate through eCourt's website, how to check case status, court orders. We also talk about proper nomenclature of parties, what a case file looks like, what are the ingredients, what are the different documents you can expect in a case file. And then finally, we give you a real case to prepare a brief on, and that brief that you prepare is evaluated by us, by practitioners. So we give you a customized feedback that okay, these are the things that you need to work on, and you keep practicing and you keep getting better. And the more you read, the more you realize, you start thinking like a lawyer, and it points you in a direction that actually helps you initiate your practice as a litigator after you graduate, from courtroom to class, from classroom to courtroom transition that is required. We try to make that easier for you, because we have been first generation lawyers, and we have, actually understood all of this from our own experience, all the things we wish we were taught in law school. And we are trying to rectify that by creating courses like this. It's a month long course. The next batch starts on 20th June, which is tomorrow only actually. After that, we have another batch starting from 20th July, and it's a self-paced course. So there are 5 modules. You can go through them at your own pace. We have live sessions every weekend. We will record the live sessions and upload them for you. And this is the practice we follow in all of the courses actually, so you can watch the recordings later. And we have one final assignment for you at the end of the course, so you'll get 1 week to do the assignment. It's a good way to upskill. You can check it out. If you want to pursue this course, you can use the coupon code LB15. Varshika, if you could just write that in the chat box. So if you use the coupon code LB15, then you will be able to avail 15% discount, or scholarship as we call it, on this particular course, for this batch also, for the next batch also, whichever is convenient for you. So you can check out this course and see the details, the course syllabus and everything, to see if it helps you. We also have legal research and writing, which will talk more about referencing and everything you've learned today. That is handled by Varshika. So over to you, Varshika.
Yeah, so very quickly, I know almost everybody is eager to leave the session, but guys, we said that it is going to be till 1:30. Anyways, so legal research is and writing, another very, very important skill that everyone, irrespective of what career path you choose, as a lawyer, a litigator, an academician, anything basically, even when you want to diversify yourself and learn, say, other social sciences, etc. Research and writing is a skill that a lawyer at least cannot do without. So another very important course is legal research and writing. And we have, like, this is a 2-month long course, and I think around 2,000 students have taken it so far. And a lot of them have gotten published at great journals, at blogs, of course, too many blogs to even count. So this is a 2-month long course. And here we are going to teach you legal research and writing. I'm the faculty, but the course is developed by brilliant scholars and researchers, Shrutanja Bharadwaj and Abhairaj Nayak. So there was recently a session by Abhairaj Nayak. Again, so we have decided to have more sessions by him, because I myself was blown away by the way he explains the concept. I have seen his work in the written modules parts of the course. So you guys can also check it out. We'll publish it very soon on the YouTube channel. But yes, if you want to join the course, please feel free. There are a lot of details regarding the course, like things that we talked about, practical skills, peer learning, all of that happens. One very peculiar aspect of the course that I want to talk about is actually the assignment. So there's a one very specific kind of assignment process, because we don't believe in simply giving you the theoretical aspects about any skill that we want to teach. We are giving you the practical experience of it. And this assignment is a 3-tier process. We don't even give you a topic. You have to select the topic yourself. So it's a complete process of writing a research paper. We evaluate, we give you feedback throughout the stages in which the assignment proceed. At each stage you get a detailed feedback from faculties from Cambridge, like the recent guest faculty for the course was Anupama ma'am. So feel free to check these courses out. Again, there is a coupon code for LRW course, which is LRW15. Now guys, one last thing is that if you want to take both these courses together, then there is a coupon code which is Sanya, could you write down the coupon code LRWLP20? So if you want to take them together, then please feel free. Just use this coupon code to register. The links are on the website, and I'll quickly share the links with you. Also, finally, we will share the link for the expression in form, based on which you will be receiving your certificate within a week.
Yes. So just to repeat the coupon codes, it's LB15 for litigation basics, LRW15 for LRW. And if you take both the courses, you'll get 20% off. So it's LLS20. You can check out the fees and everything, all the details, all the subject matter that you'll be dealing with on the website. We will share the links of them in the chat box shortly. Another thing that, guys, I want you to also check out is this reading resource, which is Concise is Nice by Georgetown Law University on paraphrasing. So I'm sharing the link on the chat box. Please go through it. It'll really help you better your paraphrasing skills. And litigation basics course, I am going to share the details.
Sanya, I'll share the link.
Okay, so Varshika is sharing the links for the courses, so you can check the syllabus and the duration, the fees, everything else. We're also going to share the form, the Google form. Now, guys, pay attention to the chat box. Okay, that is our main mode of communication with you. So please pay attention to it. I'm going to share the expression of interest form. So you have to fill this out, and then once you filled it out, only then we'll know you attended till the end, and only then you'll get the certificate. So I'm sharing it. Just keep the form, open the link, keep the form with you, so even after the session you can access it. Okay, so Vaishika is sharing the links to the course. Now we have some time left where we would like to take up your questions, some of your questions. I know in these kinds of sessions, it becomes a little difficult for us to also interact with all of you. We have limited time and a lot of people and a lot of things to, just say. So we don't get a lot of time to interact. But we will take up questions from all of you. We have prepared one end of session quiz. So there are 5 MCQs for you to make sure that you are taking away something meaningful from this session, and you are able to highlight your key takeaways, and you're able to retain that information. You're going to see a poll on your screens. I will just launch the poll, and once you see it, you'll get 5 minutes to answer the questions. So please try this quiz. It will help you gain a better understanding of the session. And we're also going to take up some questions. For those of you who have to leave, they can leave at 1:30. We understand people have other engagements. We can stay back for 5-10 minutes to take up some of your questions. We'll stop the recording and interact with each other for another 5-10 minutes after the session is done. So feel free. We're giving you 5 minutes now to attempt this end of session quiz. I'm going to read out the questions and the answers at the end of the 5 minutes.
Guys, I'll also share a link of another WhatsApp group because apparently the group is full. Just give me a second, I'll share the link with you. please try joining this group if it is purposes.
Right before Varshika has shared the WhatsApp group link, I have shared the expression of interest form link again. I'm going to share it again. A lot of messages keep coming on the chat box, and I don't know why we don't have a message board here where we could just stick one message right over there for all of you. So don't worry about the WhatsApp groups. We'll be creating new groups and we'll add more of you. You can send us an email in that regard. Even if it is full, don't worry. And some of you can't see the questions of the poll. That's also all right. Don't worry, I'll read out the questions after 5 minutes. And I'm putting, guys, for the last time, I'm putting the link of the Google form again on the chat box. Keep it with you. Fill it out. Only then you will get your certificates. It's not exactly a feedback form. It's more like we want to know where your interest lies. So yes, I'm sharing it again and again and again. You'll get instructions to download your certificate after within a week once we receive all the responses on the form. Neetu, you just have to click on the link. It will open on your browser, the form. You can't download it. You will open it and then you can fill it out. Okay, guys, most of you have answered. I'm going to end polling shortly now. And we're going to just quickly go through the questions so you can keep some key takeaways and some keepsakes of this session with you. So I'm ending poll and I'm sharing the results. The first question that was asked was, which of the following would you make on a judgment while preparing for a court hearing? And you were given multiple choices, analysis or comment, brief, either of the above, none of the above. So while you can make an analysis comment for your publication, and like we discussed throughout the session, for you to get a deeper understanding of the case, at the time of hearing, you'll be better prepared if you have a brief with you. So 67% of you have answered that correctly. The second question was, while critically analyzing a judgment, should you share your opinion? So yes, 76% of you have said yes, exactly. When you are critically analyzing, you're applying your mind, you have to share your opinion. And that, like Vashika had told you, it makes a 70% of your case comment. So yes, the answer was yes. The next question was, what does paraphrasing mean? First option was same thing, different words without changing the meaning. Then we had summarizing, highlighting the important points, or opining. Now, all of these terms are confusing, and that is why we put them in the options for you to get a clarity that when you summarize, when you highlight, when you opine, you're not necessarily not changing the meaning of what is being said in that particular sentence, in that particular document. While paraphrasing, you have to pay attention to the fact that you don't change the meaning. So the correct answer was you say the same thing in different words without changing the meaning. Then the fourth question was, do we have to file the brief on a judgment before the court? I am surprised that 44% of you have said yes. The correct answer is no. 56% got it right. You don't file it before the judge. There are certain cases where you can, draw a family tree or sorts to make the judge understand the relations between parties better in some criminal cases or in some property disputes or things like that. But you don't prepare your brief to file before the judge. You prepare it to refer to at the time of hearing. And the final question was, critical analysis is important only for academic writing. 41% of you have said true and 59% have said false. The correct answer is false. It helps you develop critical thinking for you to be able to really understand what is being said, which helps you to think like a lawyer eventually. So it is good for academics also, it is good for practice also. There is absolutely nothing that can replace your knowledge, and knowledge is truly power in the field of law. Whether you're going for academics, whether you're going for practice, whether you're going to work in a company or do whatever, you have to absolutely know what you're talking about. And the deeper you understand it, the better it is. And judgments form just a very small part of it. They help you eventually think and question everything, and then assist the court in delivering justice. So you have to be at your best. There are no shortcuts, and your sincerity, your hard work will definitely go a long way. And just like the judge has said, I am the society. So whatever I do reflects on the people around me, reflects on the things that happen to me. So if I am putting my best foot forward, I am raising the bar for everybody else to also improve themselves, to better themselves, and to be more just, more inclusive, more kind, more understanding. Everybody just gaining knowledge. So please put your best foot forward. Now, with that, I believe, Vashika, if you have anything to add to that.
Right, guys. So thank you so much, everyone, for joining. We had a lot of participants, and if you like the session, just understand that this is how we generally tend to make our classes also at Lawctopus. So if you feel like you want to check out the other courses, feel free to do so. And it's really great, guys, that you are sharing this course. We're really happy to see it. I see a lot of questions on the Q&A box. It's already 1:30, so we will have to officially end the session here. But if you wish to get questions answered, stay back. We can stay back for another 10 minutes to answer some of your questions. We tried to answer as many as we can, but there were just too many. So feel free to drop out. I think make sure that you fill the expression of interest form to get your certificates also, as well as check out the other courses as we have already shared with you. And it'd be great to have you for a longer term. And thank you so much again for joining. And I saw a lot of great comments on this session. Thank you for being so kind. We try to do our best, and we really hope that you took something away from this session and you are able to use skills. Even though it was a very specific skill, these were like just two things that we wanted to share with you, because a lot of people are confused about these terms: case note, case summary, case brief, case comment, case analysis. So we tried to provide you as much clarity as we could, and we really hope that you have that clarity which we intended to provide through this session. And again, thank you so much for joining in. We hope to see you soon. We will share as many things as we can. So the case analysis probably will not be shared as of now, but as soon as it gets published, I will be happy to share the link with you. So you can feel free to read it. I would encourage you to not just read the judgment which you intend to analyze, because it is a wider approach. It's not really just about the judgment, but about a lot more things, about the concepts which are discussed. Just make it a habit to read, be it for case brief, be it for analysis, be it for academic writing. Just read as much as you can. And I know it's as boring as it is, it really gets interesting after a point of time when you start connecting things with each other. So yeah, with that being said, I think it's time for us to officially close the session. And it was really great to have had the chance to talk to you. Again, feel free to stay back for a few more minutes. We'll take
Yes.
a couple more questions and we'll officially end the session here.
We'll stop recording now. And Umang, if you could stop the live telecast. Thank you so much, everybody. So